Hi, warriors. This is Jaylyn, my legal warrior. And today's segment is going to be about the UCCJEA. So, what does that stand for? The Uniform Child Custody, Jurisdiction, and Enforcement Act. You might hear this term a lot used in court, or even the term Family Code 3048 findings, that the court has to make 3048 findings with every child custody and visitation order. And so if you are in a situation where there are no court orders, there's nothing filed to even start the proceedings for a child custody and visitation order, and it's not an emergency, you and just the other party are having a dispute as to how to reach an agreement for a child custody and visitation order that is agreeable between the two of you, then the court at some point is going to need to make Family Code Section 3048 findings, and it has to conform with the Uniform Child Custody, Jurisdiction, and Enforcement Act. And so I wanted to take a look at what the court has to do, what the court has to actually find in order for it to have jurisdiction, in order for it to have authority to make child custody and visitation orders. And perhaps it would be not appropriate for you to file in a certain local courthouse if you recently moved to a place and there's not an emergency and there's just no reason to file anything at that point in time, even though there's a dispute between the other party. After we first look at what is Family Code Section 3048, like why do they keep saying, oh, the court makes Family 3048 findings? Well, let's see what those findings are. 3048 findings. So notwithstanding any other law in a proceeding to determine child custody and visitation with a child, every child custody and visitation order shall contain the following: that the basis of the court's exercise of jurisdiction, which is going to stem from the declaration under the Uniform Child Custody, Jurisdiction, and Enforcement Act, the manner in which notice and opportunity to be heard was given. So if the parties were at the hearing, or if the parties, or if one party was at the hearing and the other one was not, but there was valid service for both parties to be present, or for the other party who decided to not be present and they're not present, but the court will still make those orders absent their presence. Clear description of the child custody and visitation rights of each party. So that's the child custody and visitation order. A provision stating that the violation of the order may subject the party, so any party, in violation to civil or criminal penalties or both. Very important section, because if you do violate the child custody and visitation order, then you might be subject to contempt. And then identification of the country of habitual residence of the child or children. So if you're in the United States of America, it's going to be the United States of America. And so the court has to make these findings. And you know that it has to, because it says every child custody order shall contain all the following. So they must make these findings in order for it to have the authority to make child custody and visitation order. So what is this declaration under the Uniform Child Custody, Jurisdiction, and Enforcement Act, which is in short UCCJEA? And so you would need to actually fill this out as soon as you file a petition for custody and visitation, or paternity, or divorce, legal separation, annulment. This form would need to be filed with any of those sort of proceedings. And so the purpose of this is to account where the children have been living for the last 5 years and with whom. And more specifically, what this is going to help the court establish is whether it has the authority to make orders in its local courthouse, where you're presenting this information. Where have the children actually been living for the last 6 months or the last 3 months? Because then that is going to give them the authority to, in fact, make child custody and visitation orders. Of course, there's exceptions to this, because there's emergency orders, and therefore, if it's an emergency, they don't necessarily need to meet certain requirements other than the fact that it is an emergency. or other steps will be taken to perhaps do a transfer or a change of venue, but that's a lot more complex than we need to get into for this particular video. But you would need to fill out this form anytime there's any changes to the residency of the child. So if they now moved outside of San Diego County, it would be prudent of you to update this form to include their new residence. And then you have to answer these questions about whether there is another case pending about these children, whether it's in California or out of state, that requires the court's attention. And if you have a copy of the order, you can go ahead and attach that. And if there is a restraining order in place, then the court also wants that information. It doesn't matter where the restraining order stems from, you still need to include that in here. And then if there's another party, a third party that wants custody and visitation or is asserting custody and visitation rights, like the grandparent, for example, then you want to inform the court of that as well, is that there is somebody that is claiming to have custody rights over your children. And so you would want to specify for which child and whom and what they're claiming. Thank you, warriors, for viewing our video. We hope that you found this helpful. I know that there's a lot of misinformation out there, especially during the quarantine, and why I thought this video was important to share during quarantine is for parents that are moving during this time for whatever reason, and there is not a case that has necessarily been established in San Diego County, then this is something for them to review, because the court, in order for it to make at least in California, in order for it to make child custody and visitation orders, they have to make certain findings. And so if the court can't make those findings, then the court doesn't have the authority to actually issue child custody and visitation orders. So you really have to review the Uniform Child Custody Enforcement and Jurisdiction Act in order for you to have this prerequisite for the court to make orders. So if you've only been here for a couple of weeks, then you're filed for a divorce, the court might take issue with that. So if you need more information, you should always consult an attorney, a competent attorney that understands the Uniform Child Custody and Jurisdiction and Enforcement Act, so they can explain to you whether this is the appropriate county to file for child custody and visitation within your underlying action. Thank you, warriors. We hope that you do share this, subscribe, share it with your clique, comment below. We greatly appreciate all of our viewership, and we hope that you are staying safe during this quarantine. Thank you, warriors.